You're watching 13 WMAZ Law Call, sponsored by Macon Law Firm, Reynolds, Horn, and Servant. Your rights, your calls, live. This is 13 WMAZ Law Call.
Well, hello and welcome to Law Call. I'm Morgan Dukes, and tonight we are dealing with the insurance companies, fighting the insurance companies to be exact, but we're going to fight them legally. We're going to do it the right way. And with us tonight from the law firm of Reynolds, Horn, and Servant is Mr. Carl Reynolds himself. How are you, sir?
I'm great, Morgan. How are you?
I am feeling good. And you know what? You're looking great. I see the neck brace has been off for a minute now, and you're
All
moving
done with
real
that.
good.
All done with that, getting better every day, and almost back to a full range of motion. So I feel real good.
All right. Well, I tell you, tonight we're going to get into fighting the insurance company, and you brought some help with you.
Right, I did. Marty Sin of our office. Marty has been in the practice of law, what now, Marty, 10 years?
About 13, 14 years.
Damn, time flies when you're having fun, doesn't it?
Indeed.
Marty's one of our go-to lawyers in the firm. He gets most of the hard questions, so he can deal with these tonight and give really good answers.
Well, okay then. Well, we've got some really tough questions because people are really, going through right now. It just seems like a time in life where people are just, going through. But we've got two excellent attorneys here to give you some good answers. So, Marty, Carl, are you ready? Because here we go. All right. Our first question comes from Kim, and she has a question about a wreck she was in. She says, I got into a bad wreck the other day, and my husband is still in the hospital, but the insurance people have been calling already. What should I do? I'm really upset, and I don't want to say the wrong thing. Now, this happens to a lot of people. When after an accident, the insurance just jumps on it. What should she do, Marty?
Well, I think Carl would agree with me. I think the right thing to do is not to say anything, to call an attorney, because you don't want to misstep there, and you don't want to jump the gun and have them get you to sign something or give up some information that needs to be protected or presented otherwise. And I don't think that's uncommon, unfortunately. I think that they will try to reach out as fast as they can, and hopefully you talk to them before you talk with someone who may know how to help you deal with them.
Yeah, it's always good to get the advice of a lawyer. And let me add this caveat. Get the advice of a lawyer who you have been referred to through reputable sources. You shouldn't talk either to the insurance claims people or any lawyer who seeks you out, especially if under these circumstances, I understand they're still in the hospital, and the insurance company's trying to reach them now. Years and years ago, they used to have a 24-hour contact policy, and that's more internal to the working of the insurance company. That claims person may or may not be under some job requirement that when they get a file to open on a claim, that they have to make an endeavor to make contact within a certain period of time. And that's their right, and they can do that. But my advice to this person would be courteous, be respectful, be dignified, and say they would love to talk to the person, but they either are planning to get an attorney or already have an attorney, and they will have the attorney get in touch with the insurance company. And that's basically what they should do.
All right. That's a nice, dignified way to deal with it. Oh. All right, then. I like that. All right, let's move on. Our next question, our next email comes from AC. And AC wants to know, says, my mom was a sickle cell patient and passed away because they gave her anesthesia and she was allergic to it. This was almost a year ago. Do I still have a right to claim anything, is his question. That's AC's questions. I mean, after a year, does he still have a right to claim anything?
Well, certainly. The general statute of limitations in the state of Georgia is 2 years on a medical malpractice, which is what he's asking about. Now, whether or not he has a medical malpractice case potentially, we couldn't say based on the information he's given. It depends on whether or not that is something that the physician knew or should have known, and whether or not they did the appropriate workup prior to, which is a surgical case.
I
An
believe,
anesthesia case.
yeah, anesthesia.
Yeah, I mean, it again, as we always say, it just depends on whether or not that act of giving her the anesthesia was something that should not have happened and would have only happened if there was negligence involved in the act. But as always, you get an attorney and talk to the attorney. The attorney will then call in the appropriate expert, in this case, an anesthesiologist, after getting all the records, and have the anesthesiologist look at it and see whether or not some test prior to the surgery was omitted, or whether if it could be a product case, I don't know. It's just too many things to answer there, but certainly by all means, get an attorney, talk to that attorney, and see if they will review the case.
Okay. All right. Carletta is our next person. Carletta emailed us a question, and it simply goes like this. I slipped and fell in a store. I went to the doctor, and I have an aggravated disc in my back. I haven't been able to work because I've been going through physical therapy. When the store's insurance man contacted me, he told me that they would not be liable, but I'm stuck with a bunch of hospital bills and doctor bills, and I don't know what to do. So what should Carletta do?
That's pretty simple, wouldn't you think, Marty?
Yeah, I think, fortunately for Carlita, the store manager doesn't get to make that determination. I mean, that would ultimately be up for a jury to determine whether the store was liable. And I mean, premises cases in Georgia are difficult. I mean, she would have to prove that there was something that the store did wrong or didn't remove or knew about or should have known about that she didn't have some knowledge of that made her have this fall. But if that is the case, then the store may very well be liable, and the store manager doesn't get to make that decision. I mean, he may make that on the front end, he may deny the claim, but then Carlita would have the legal process and the litigation process to have that kind of explored a little bit and heard before a jury ultimately, and she would be entitled, if the jury agreed with her that the store is liable, she would be entitled to recover those medical bills and her pain and suffering and lost wages as well.
That's right. In the parlance of most lawyers, this is a slip, trip, and fall case. And actually, they all turn around knowledge. They fall into a couple of different categories. There is a patent defect and there's a latent defect. If you walk across the front porch of a house and there's a rotten board that's been painted over, to all appearances, it looks normal. You step and the board breaks and you are injured, then you might very well have a claim if the owner or occupier of the premises either knew or should have known through reasonable inspection. I believe this was a grocery store, wasn't it?
She didn't say, she just said store.
Slipped and fell in a store. Okay, it could be almost anything. It could be spillage on the floor. Like in a grocery store, we had a case one time where there had been grapes and lettuce that had been left uncleaned for a long time, and it had turned into kind of a putty-like paste. And a client of ours, who happened to be a physician himself, walked through there, his feet slipped out from under him, he fell down and broke his back. Well, that condition should have been observed by the store people and cleaned up, and it had been there for some period of time. So time is an important factor in that too. And then there's always then the open and obvious danger. If you're walking down the sidewalk and somebody left a manhole cover off of an access to the sewer system, it's open and obvious. You're looking at it. You can't just walk into it and claim that it was a defect in the premises. But they're all fact intensive. It turns around the facts in each case. And Marty is completely correct. It's not up to the store manager or the insurance adjuster to decide that. It would require somebody to go out and investigate it and determine what the facts were, whether or not it was a defect that should have been taken care of by the store, and that it was something for years and years and years. There was one case where there was a clear plastic hanger on a terrazzo floor in a clothing store. So being clear plastic, you actually just see the floor. And a fellow stepped on it, and that slid out from under him. He was hurt. The Supreme Court, and in discovery on the case after the suit was filed, the defense lawyer asked the injured party, well, did you see the coat hanger? And he replied, no, I didn't see it. And this was incredible. It speaks to the difficulty sometimes in our Court of Appeals. The lawyer then asked the client, asked the injured plaintiff, if you had looked, would you have seen this clear plastic coat hanger? To which the plaintiff responded, well, yes, if I had looked, I would have seen it. But as in most stores, he's looking up at the goods they've got to sell. But our Court of Appeals, and it's not the current Court of Appeals, so I hope nobody takes issue with this. It was many years ago, and it was a historically bad decision. But the Court of Appeals then said that the trial court should kick that case out on summary judgment because the client said he could have seen it if he'd looked. Well, the law has changed since then. It still now revolves around facts, what the facts are, what is reasonable is more or less the standard now. Either the store should have known about it, or could have fixed it. The person who was injured didn't see it or wasn't aware of it, certainly didn't do it on purpose. So yeah, it's a case that would have a fact issue for a jury to determine, not a claims adjuster.
All right. Carl Reynolds and Marty Sin from Reynolds, Horn, and Servant are our attorneys tonight. Fighting the insurance company is what we're talking about. I'm Morgan Dukes, and we'll be back with more of Law Call.
You're watching Law Call on 13 WMAZ with personal injury attorney Carl Reynolds, who has recovered more than $500 million for his clients, dedicated to helping injured Georgians for more than 50 years, plus support from his Macon law firm of Reynolds, Horn, and Servant, including attorney Wendell Horn, focused on protecting the rights of car and truck wreck victims across the state, and attorney B.J. Servant, aggressively representing those injured by medical malpractice, hosted by award-winning broadcaster Morgan Dukes, featuring guests from across Middle Georgia. Your rights, your calls, live. This is Law Call on 13 WMAZ.
And welcome back to Law Call. I'm Morgan Dukes, and tonight we're talking about fighting the insurance company. And every now and again, we have to get into that type of fight, but that's okay. We got two great attorneys here tonight to help you with that fight. Carl Reynolds and Marty Sin from Reynolds, Horn, and Servant. And gentlemen, let's get back into our questions. We have some good email questions here, and this one is from Eric. And Eric's question is, I was sideswiped by an 18-wheeler. Pretty serious damage done to my car, but I was able to get the driver's information. The problem is, when I called his insurance company, they told me that they only cover damage to his truck and not my car, and that they'd need to contact, or that I'd need to contact his other insurance company. But now he won't even return my phone calls, so I can't get that information. Any ideas on what Eric should do? Marty?
Yeah, Morgan, actually, we have a case right now where this is the exact scenario. And unfortunately, Eric is probably going to need to hire an attorney and file suit to get the information he needs. He's unfortunately trapped in the world of dueling insurance policies, and gets even more complicated when there's an 18-wheeler involved because the coverage that applies depends on what the truck and the truck driver were doing at the time. Whether he was hauling a trailer, if he wasn't hauling, that's called there's a bobtail policy that covers basically just damage on the truck. If he was deadhead, meaning he didn't have a load, then there may be another policy that would cover that damage. If he was hauling for someone, if he actually had a load, then he probably had a broker that brokered that freight load that's going to carry insurance on that load. So what's happened here is he's identified the insurance company that provides the property damage on the truck only, meaning that because he was probably carrying a load, then this company is only going to pay for the damage done to his truck. So what he's going to have to do is find out who insured or who provided the liability policy through the carrier that he was hauling this load for, is what I suspect has happened here. And he's going to have to identify that, and really, short of a few avenues that he could explore online, he's probably going to have to sue the driver, maybe even depose him, or send what's called interrogatories, which are written questions that you can ask to get to this layer of coverage. He's going to have to find out who that carrier was, so he can find out who their liability carrier was, so that he can find out who's going to be liable for the damage that this truck caused to him, both for his property damage and for his physical injuries, because the company who provides the damage or the property damage coverage for the truck that he's mentioned is probably not going to be liable for the damages caused to him, because they probably have exclusions in there that prevent them from having to pay that when he's carrying a load. So he's going to need to find that information, and the only way he really can compel that is to file a lawsuit. Is the only way he's going to be able to make that truck driver respond to these inquiries.
Okay.
Well, yeah, there's all that is well and good and true, and those are the remedies that Eric has. But I would like to add that there's an important principle here, and that is that anytime you have an accident on the road with another vehicle, the first thing you should do is call the police. And then the police will come and they will get all of that information at the outset. And the police report should have the driver's name and address and contact information. It should have the insurance that covers the truck. The way the question was framed was that whoever Eric had contacted told him that they only covered the property damage to the truck, which would be the same as collision insurance on a truck with no liability insurance on it. I doubt there's any tractor trailer truck on the road with no insurance. But again, if he'd called the appropriate authorities, they would have come, investigated. They'd have gotten all that information, including his driver's license number, his address, the insurance that covers the truck, and Eric wouldn't be in this position that he's in right now. He would have all that information. And then he could go through regular channels. Now, he didn't say whether he was hurt or not, mostly his property damage. But as in all of these cases, I mean, especially if there is any difficulty, you should talk to a lawyer. Lawyers most lawyers who do trial work and handle damage suits, which is what this is, they will talk to you for free. And in that case, if Eric didn't have any personal injuries himself, a lawyer probably, as a courtesy, would tell him how to proceed on his own.
Fighting the insurance companies is our topic for tonight. I'm Morgan Dukes. We're going to take a quick break and we'll be back with more of your questions right here on Law Call. And welcome back to Law Call. I'm Morgan Dukes. Now, if you want to have further discussion with our attorneys tonight, Mr. Carl Reynolds or Marty Sin, well, you can reach them at Reynolds, Horn, and Servant right here in Macon. Their phone number is 478-405-0300, or you can follow them on the web at www.reynoldsinjurylaw.com. And don't forget to check them out on Facebook, too, at Reynolds, Horn, and Servant. You'll see a lot of good stuff there. And speaking of which, Mr. Reynolds, and Marty as well, but Mr. Reynolds in particular, do you all have any new protocols at your office? I know you are accepting clients to walk in and what have you. So are there any new protocols in place?
No, we're during the lockdown, we had everybody work from home except the lawyers and bookkeeping. And we brought them all back. And then we have the appropriate signs out that if they don't have a mask, we will give them a mask. We wear a mask in the halls. We do, fortunately, we have big offices, and we do social distancing and wear masks with the clients, but we're careful with it. Nothing new. We just don't do gatherings in the office.
I see. Now, even in the mask department, you have a specialty going on, right?
Oh yeah, that's right.
You got your own mask. I like that. I like that. That's really nice.
I believe it came up on the screen.
Yeah, it looks good.
Somebody hoodooed us on them though, because we're supposed to have them big enough to see our firm name, and it's microscopic, but it's easier just to use them than to send them back.
Okay, I agree. They do have purpose. They do have purpose. Well, let's get back to our questions tonight. And our next email question comes to us from Stephanie, and she was in a bang up. Stephanie's question says, I was involved in an accident where I was rear-ended by two other cars. One of them hit the other, and then they both hit me. They were both doing at least 50 miles per hour. So who do I need to file a claim against? The last person in the very back or both of the people that hit me? That's a fair question from Stephanie. I know somebody who was in that exact same situation. So what is the answer to that, Mr. Reynolds?
Well, and the conventional wisdom is you sue everybody who may have been a causative element in the transaction. By that I mean if the trailing car hit the leading car, knocked it into Stephanie, then probably both of them bear some responsibility for not having stopped and controlled their speed so as to avoid an accident on the highway. So yeah, you would talk to a lawyer. The lawyer would probably contact both the insurance company for both of those drivers and commence a claim. And then depending on what her injuries and damages were, they would then get that worked out.
Okay. Marty, you have any thoughts on that?
No, I agree. I mean, I think it's one of those cases that's very fact sensitive, and you need to find out what happened. But I think you would err on the side of caution to anyone who is, will be sued.
Okay.
The problem with that kind of case, in any kind of case where you have multiple parties as defendants, and they want to get into a contest over who was more at fault, especially here in Georgia, where we have apportionment and that kind of thing as to the degree of fault, it always works as an impediment to a smooth resolution of the case. That is, you get into a lawsuit with that, you go to mediation, and then they spend all day arguing over who bears the most responsibility. Sometimes they're resolved and worked out, but oftentimes not. And you have to wind up letting a jury decide that.
Okay. All right. Carl Reynolds, Marty Sin, it has been a pleasure to have both of you with us tonight. So until next time, it's time for us to say goodnight. So from all of us here at LawCall, good night, everybody.
Good night, Morgan. Good night, everybody.